Thank you. Everyone, please be seated. We are here this afternoon for the case of Auditor versus an unnamed local government risk pool. And for the record, to my left is normally Justice Mansfield. He will be participating in this case. He cannot be here for the argument, but will be observing it. It's live streamed, so he will have a chance to watch it later. And then after that will be the case of Gov't versus Iowa Utilities Board. And he will not be sitting on that one. So thank you. Looks like the parties are ready. Mr. Rousseau, you may begin.
May it please the court, counsel. If it walks like a duck and quacks like a duck, it's a duck and not a chicken. And the duck we're talking about is a local government risk pool here in Iowa that we're going to refer to as the pool for confidentiality reasons. The issue decided by the district court that we think was decided in error is that the pool is not a governmental subdivision, as that term is defined in the Auditor of States Enabling Statute, Chapter 11. And because it's not a governmental subdivision, the auditor doesn't have the authority to conduct a re-audit. Now, before we jump into that issue, which I believe is an issue of first impression here in Iowa, and we're happy that you are getting an opportunity to weigh in on it. I want to give some brief background. I mean, this case isn't quite as complicated as the predecessor case you just heard, and so I just want to take a minute or two to give you a little background that I think is relevant. In September 2019, the auditor became aware of some news reports that board members of the pool had undertaken excessive out-of-state travel for annual public meetings and other business, and believing the pool to be of, by, and for government bodies and funded entirely by taxpayers and the fruits of taxpayer contributions, the auditor sent a letter to the pool indicating his intent to review some of the pool's transactions and records for a defined period of time. But this was met with resistance by the pool, who indicated that the auditor didn't have jurisdiction over them because they weren't a governmental subdivision under Chapter 11. So a series of back and forth communications and some initial legal proceedings ensued, but they didn't resolve the issues between the auditor and the pool entirely. So ultimately, there was a subpoena issued by the auditor under Section 11.51, and the pool objected to the auditor's authority, but
Section 11.1, sub 1, sub C, governmental subdivision means, it says, and then it has a list of specific examples of what that means. Is your argument here that the pool constitutes an entity organized under Chapter 28E, or is it something broader than that, that this list sort of refers to kind of a concept of what a governmental subdivision is, and that it doesn't have to be one of these particular items, it can sort of maybe straddle the lines among them?
I don't think we're arguing it quite as you phrased it. We are arguing that this entity is in substance a 28E entity. That's really the only statute that it could organize under. But holistically, I think the district court's interpretation presents an absurd result. And I know here in Iowa, we try to avoid absurd results when we can. And namely, that interpretation that this is somehow an entity that's not 28E, but formed under 670.7, Section 670.7, the Iowa Municipal Tort Claims Act, that and that the local government risk pool formed thereby specifically is not regulated by the Iowa Insurance Division. And so the absurd result here is if the auditor cannot audit this entity and it's not regulated by the Insurance Division, then there's effectively no meaningful oversight over this organization, and it is has collected and operates and feeds off of tax.
When was ICAP formed?
It was formed in 1986.
Been operating with the knowledge of hundreds of municipalities, government officials since 1986. Everybody knows that it's not subject to oversight by the insurance commissioner. Until this suit, the auditor never claimed authority to subpoena it. That strikes me as working as intended by the legislature.
Well, I don't know if I agree that it was working as intended. I mean, it's been flying below the radar here. It hasn't been submitting its audits to the auditor, and I don't think it's fair to say that it's been operating with the auditor's knowledge, consent, and approval.
It's on the website. That really doesn't seem like under the radar to me.
The website is there, and you know to look there, perhaps.
Government officials had no knowledge ICAP has been operating since 1986, even though it's comprised of 800 different local government entities.
That. But what I'm saying,
It's absurd that the government didn't intend for it to operate this way.
absurd because 670.7 doesn't mention anything about how to create the local government risk pool, and
That this is a 28E entity. Why does that justify a remedy of auditor subpoena?
well, it justifies the remedy of an auditor subpoena. It's a local government. I mean, strike that. It's a government subdivision, and they conduct their audits using a private CPA firm. But where there's a material deficiency, and here I think the material deficiency that came to the auditor's attention were these alleged excessive out-of-state travels for public purposes.
Your contention that it should have been organized as a 28E, and if it were organized as a 28E, then the auditor would have subpoena authority. But if it wasn't, and let's assume it wasn't, let's assume maybe that's even illegal, why would that mean the remedy is that the auditor gets to subpoena the entity as opposed to dissolution of the entity?
I don't think anybody's wanting to dissolve the entity. It performs an important government service. In fact, it performs an important government service that all of these members could perform in-house if they chose to do that. And I don't think there's any dispute. If they chose to do it in-house, the auditor would have oversight over those activities as they would any other activities in those government subdivisions.
Service then, I guess, which is the case that you say that recognizes de facto 28E entity, correct?
And the Spanos case, Your Honor, yes.
Was being sought in Hawkeye Food Service was to declare the entity at issue to be illegal and all of its actions void. So if your de facto 28E theory is correct, Hawkeye Food Service comes out the other way, and the court would have said, well, whatever you did, we're going to call it a 28E. But that's not what we said. What we said was, okay, the case can continue and you can dissolve the entity. So where's the authority for a de facto 28E that subjects this entity to the auditor's subpoena?
I think there's, obviously, this is a case of first impression, this specific point we're making. We cited that case, Hawkeye Food Service and the Spanos case, for the general proposition that the substance of the activities of the entity will govern the court's interpretation, not what the moniker that anybody, the label that it gives itself, which is the case here.
Hawkeye Food Service stands for the exact opposite proposition. The court didn't say we're going to treat this as a de facto entity because it should have been organized that way. What it said is the plaintiff's case can proceed to dissolve the entity because it was formed illegally. So it's the exact opposite of what you're saying it says. Okay.
I think we cited those two cases for that general proposition, but if, I understand what you're saying. That was a motion to dismiss case.
The remedy being sought was dissolution of the entity to declare the food purchasing contracts void. And the court said, not that we're going to treat this as a 28E entity and just bless whatever had happened. We said, go ahead and proceed, and you can dissolve the entity. So I don't find any authority for this de facto 28E agreement Now, if you think I'm misreading Hawkeye Food Services, tell me where in the opinion it says something to the contrary.
I think we cited it for this general proposition that appears on page 612, and that is, the issue is whether the entity formed as a result of the cooperation among the area education agencies is the type of entity that still must be governed by a 28E agreement. That's really the sole point that we lifted from Hawkeye Food Service. And it was a recognition, we thought, that if in fact the reality was that it was the type of entity that should be governed by a 28E, then the court would deem it as such.
We say if it was the type of entity that should be a 28E, then it should be dissolved because it was illegally created.
That was the remedy that Hawkeye Food Service was seeking. We're not seeking that here.
If we would say that this risk pool is not a 28, it wasn't created as a 28E, we're not going to call it a 28E, we're going to call it something besides a duck. Are we incentivizing others in our state who are funded entirely with public funds to follow suit and get around a state audit?
Brings up a good point, Your Honor. That's part of the, I'd say, the absurd result that I was referring to. Again, if these are activities, if performed within these governmental subdivisions that are under the jurisdiction of the auditor of state, and that somehow by coming together as government subdivisions and setting up an entity, as is described perfectly in Chapter 28E, but that somehow by doing so, they escape the jurisdiction of the auditor simply by saying, hey, we're not a 28E entity, we're something different. I think that that's a concern. That's the absurd result, is that, when it...
Absurd, because I kind of think it's absurd you guys didn't know about it too. I mean, after however many years. So there's a little bit of yin for that yang. But are there any other entities? That's why I'm kind of afraid to ask this question, because this one, quote, flew under the radar for many, many years, longer than some of my children have been alive. But are there other entities out there who are funded 100% with public funds that don't get audited by the state, to your knowledge?
I'm not aware of any, Your Honor. I think that this is quite a privileged status that this particular entity enjoys. I think it has a lot of taxpayer funding flowing into it annually and under its supervision. And I don't think the legislature intended for these types of organizations to operate without any meaningful oversight. Now, that is not to...
To fix it instead of us? Should the chapter be 670 perhaps be looked at to make sure this doesn't happen?
Well, potentially that could be a good fix, but we don't have that legislation presently, and so we're asking you to interpret it according to your long-standing, well-established rules of interpretation, that you're not going to read words into a statute or enlarge the provisions of a statute. Where a statute is silent, I think here, 670.7 clearly...
Part is silent. I mean, I think we're back to where Justice McDermott started with, if you read 11.11C, it's very specific about what a governmental subdivision is. The pool is not a 28E entity, even though it might have some of the characteristics. I mean, 28E itself, point 8 says, before entry into force, an agreement made pursuant to this chapter has to be filed. It's clearly that it wasn't. And so I think the discussion is, this is a legislative determination. The legislature has identified who the auditor has ability to audit. Where is it that what are we supposed to be interpreting other than this absurdity rule to give you the authority that you're suggesting?
670.7 says that government subdivision, or municipalities rather, can join a local government risk pool, can join and pay funds into. Those two things. The word form or create doesn't exist anywhere in 670.7.
And it does. I'm just saying that it's not one of the things that's identified in 11.11C. The only thing you've identified is 28E. It's not a 28E organization. So what else is it within that list?
Your Honor, I'll answer it this way. The only reason that they didn't satisfy the filing requirements under 28Es because they decided they weren't a 28E entity. But they followed all of the mechanics.
Who decides if you're a 28E entity? It seems like that the entity is the one that gets to decide whether or not they're a 28E entity by filing.
That in this particular case, if you're a government and you want to join with other governments under contract, then the authority to do so is in 28E. If you want to create a separate entity to carry out your government functions in joint and collective action for mutual advantage with other government subdivisions, then the authority to do so is 28E.
Chief, can I ask one question? Even though your light's on. I know your answer is that, I mean, your answer in your briefs was that this was not raised below, but what about the idea that it's just an unincorporated nonprofit association? I mean, is your suggestion that the only way that governmental entities can join together is through a 28E organization, and so therefore it has to be that? Or are there other, like an unincorporated association, that it could be?
I think that 28E, if they're going to form for their government purpose as they did here, it would need to be a 28E. I think it's a strained interpretation is put it under 670.7. They raised this unincorporated association last minute, as we said, and they're searching for an identity when all along their identity's been 28E.
Do other statutes, including home rule statutes, have with respect to the creation of the risk pool, and specifically 331, 301, 41, and 364.4, which, as I read them, authorize the creation of risk pools for insurance. And then there's statutes relating to 17 fairs under 174A8, school districts under 296.7, county hospitals under 347.13. Could those statutes provide authority for the creation of the risk pool in addition to 670.7?
Well, the thing you always hate, I'm not familiar with those statutes. I'm standing here, so I can't really address that question. I'm sorry. But my time is up. Yeah.
Yeah.
Thank you. May it please the court and counsel. Andrew Tice on behalf of the Unnamed Risk Pool. Obviously, always come in as the appellee, you hear so many things, you want to address them, and it takes everything out of order. One thing I do want to address, though, was one of the final points in response to some of your questioning, Justice Oxley. The concept of an unincorporated nonprofit association was not raised last minute. These proceedings were initiated by the auditor's application to enforce a subpoena. To assert that the pool here is an unauthorized, or not an unauthorized, but an unincorporated nonprofit association would not be an affirmative defense. The response to the auditor's application is simply that there is no jurisdiction here to pursue the subpoena. So there wasn't necessarily a responsive pleading that would be an affirmative defense. But instead, what we did do at the only evidentiary hearing in this matter is we presented the letter from the Department of Treasury, the IRS letter from 1987 that said this is an unincorporated nonprofit association. We not only presented that into evidence, but we also had the chairperson of the pool testify with regard to it, and he testified that that is consistent with his understanding as to how the pool has operated. Then finally, the only opportunity we had to brief the district court was a post-hearing brief where, again, we raised this subject and said this is actually a 670.7 entity that exists as an unincorporated nonprofit association. So this is not something that was raised last minute as we get here on appeal. That was brought up at the district court.
As I stare at this language in 11.11C, entities organized under Chapter 28E, it says organized under, and your counterpart argues that the way that this was set up actually does show that it was organized under 28E, at least that they did all of the same things that you would do to organize under 28E. What's your response to that?
disagree. If we're focused on that word organized, I think it's more broad than what we've even seen from the auditor's office here. What they're arguing is that the agreement between the risk pool and all of its members tracks 28E.5 and the minimum statutory requirements. Well, it does meet those requirements as it would other statutes such as 501B, the Unincorporated Nonprofit Association. It's a very thorough contract. It covers an awful lot of things. In fact, it covers an awful lot more than would be covered by either of those statutory minimums. Our position, as we briefed, is that any good contract under these circumstances would meet those minimum thresholds. But of course, the contract doesn't reference 28E at any point. It certainly doesn't rely upon it. It says right in the contract that it's organized pursuant to 670.7. But the term organized
To get to that, the term organized. Go ahead.
it would be more broad than simply looking at the language of a contract and trying to figure out is it sufficiently similar to meet some unknown test. But it also includes these other statutory requirements, 28E.8, to file these documents with the Secretary of State. There's the required filing of the initial agreement. There's also filings of amendments, modifications, terminations, initial reports, biennial reports. None of that was done here. And one thing I'd point out that we didn't address in the briefing was not only is the evidence clear and in the record here that the risk pool never filed any of these documents, which the statute says shall be filed before entry into force, but there's also no evidence in the record that any of the other 800 members of this risk pool ever filed it either. And I think that's significant just in the respect that to the extent the auditor wants to argue that the risk pool was flying under the radar for years, which we would disagree with, that would also suggest that 800 or so members were doing the same, which we don't think they were, and quite frankly, it'd be pretty shocking to think that after all of the auditing I'm sure the auditor has done to governmental subdivisions over the years, it has never come across any payments or any indication of involvement with the risk pool.
Line is, you guys are made up of a bunch of public funds, public entities. I mean, it's got counties written all over it, cities written all over it. Bottom line is it's 100% public entities. So just because you didn't call it a 2080, I think this is where we get to the duck stuff. What are you then? You can't say you were created pursuant to the other chapter because that doesn't have to do with creating it, 670.
Tort liability statute, yeah, I mean, that's a statute that says you got to be something. Now, I mean, the risk pool itself has viewed itself as a 670 entity. I think that's clear from the records over the 30 or so years of its existence. I'm not disagreeing with you, Your Honor. That statute says that the legislature recognizes these municipalities' ability to join and fund risk pools. And we believe that statute then allows them, in addition perhaps to the home rule authority of cities or counties, in order to have an unincorporated nonprofit association under 501B.
Notice you did not say form. I mean, there's no forming under 670. So I guess just because you don't call yourselves 2080, and I don't think that means you get to call yourselves 670s either. I mean, I never hear that getting thrown about between counties and cities. Hey, we're a 670, we're a 670. Never. It's always 2080. So just because you didn't call yourself that, address that.
So I think it starts with that 670.7 only because that's the way they've thought of themselves, but it's not necessarily any mode of operating going forward. And that's why, going back to 1987, it's also been viewed as an unincorporated nonprofit association, which is recognized under Iowa law as an entity, a 501B. Does that address your question? I, like you, haven't heard that kind of language spoken around that we're 670. What's interesting is in this case, though, the record shows that that is precisely what the chairperson of the risk pool testified to, is that they have openly called themselves that over the years.
But objected to a state audit.
Never fallen within the statute is what we would say. And so recognizing the issue with regard to a public interest in an entity like this that is receiving public funds for its work, the risk pool here hasn't held back documents that have been requested. They've provided we believe all, the auditor disagrees with that to some extent and says there might be some more. The only real crux of dispute by way of documents are claims materials that the pool holds on behalf of its members, that it has a rightful concern if it got released publicly, that it doesn't want to hand that out. So the pool has been very public with regard to what it's doing, not only in producing these documents voluntarily, but also publishing its audits. It's
In Sand versus Doe, where you don't get to be the one to decide. If I'm the auditor and I'm asking for stuff, you don't get to be the one to say, I'll give you this and I'll give you this, but I'm not going to give you this. I mean, you just want them to trust that the only thing you're asking for is claims. Isn't it the auditor's position to get to decide whether or not it's relevant for his investigation?
Auditor, I mean, certainly has some prerogative in the subject, but I think the auditor has the burden when it goes to court to enforce a subpoena to show that the documents it's seeking are relevant to an authorized investigation.
In the record, and I'm sure you know it better than I do, that that this was, what's the words I want to look at? That they were looking at the re-audit because of some abnormalities. I can't remember the word was that we used. But is there anywhere in the record? I looked at the actual subpoena, and I didn't see in there that there's some informalities or some irregularities that we're looking at. Is that anywhere in the subpoena?
In the subpoena, any irregularities with regard to how the
Or some maybe a redo because the public audit that was done initially may have left them with some questions?
No, I don't believe, Your Honor, that that's in any or either of the two subpoenas that are in evidence.
Deficiency, that's what I'm looking for. Whether there was a material deficiency, is that mentioned anywhere other than people are curious about it?
Not mentioned anywhere, but when we had the evidentiary hearing before the district court, the auditor's investigator had an opportunity to testify, and he testified, he openly acknowledged that these claims materials had to have nothing whatsoever to do with the investigation being conducted by the auditor, which was simply limited to these travel expenses for board members to attend out-of-state meetings. So,
Created by 28E agreements can also be classified as nonprofit associations under 501B.
heard of such a thing. To say whether they exist or not, I don't know. I've just never heard of that. I would think, though, I mean, our position, of course, is that if you're going to make it into the classification of 28E, you have to have these documents filed with the Secretary of State. So you could have it that way, but I don't know of any similar requirement of a nonprofit.
The auditor's position that there is no authority for municipalities to act jointly outside some statute, and 670.7 just doesn't get you there because it doesn't talk about creating an entity.
The one area where we don't have anything in the record is what entities were party to the agreement here at the outset. I mean, we know the parties will join and possibly leave over the 30 or so years of its existence, but at the outset, we don't know who it was. But we would submit that Home Rule Authority would provide, if it were cities or counties, the authority to do something like that in order to further their own needs.
All the travel expense documents turned over to the auditor?
To our belief, that's all been handed over, and there was no intention to ever withhold any of those materials.
Is the case moot?
Moot if the investigation were to be, I think, limited to that subject, which is the only one identified by the auditor, but we have this dispute over the claims handling materials.
What weight, if any, do we give to the pool's board chair's reference to 28E filing some years ago?
Mark in 2002. I don't think at this point the court would put too much weight into that. The chairperson obviously testified to it. His testimony was that he didn't prepare the document, but he did sign it, and it was his own oversight in signing it and not catching that box had been checked. He, of course, I think, remedied that error 7 years later and long before any of these auditor proceedings by signing one that was indicating a 670 entity. But I think what that really is the auditor's argument is based upon a credibility question, really, whether or not we're to believe this chairperson. And the district court had the opportunity here to hear that testimony and see it live in person and even engage questioning directly from the court to the chairperson and ultimately, obviously, discarded the auditor's concerns. So we think that's probably a question that's best left to the district court. Okay. Well, absent any further questioning, We would respectfully request this court affirm the district court's dismissal of the auditor's application to enforce the subpoena, because we believe, first off, that this risk pool is not an auditable entity under the auditor's authority under Chapter 11, and also because this investigation here is not an authorized investigation under, I believe that was 11.6 subsection 4, the 3 particular circumstances in which you can actually re-audit a governmental subdivision. And our understanding is the auditor has acknowledged 2 of those don't apply. The only one that the auditor relies upon is this probable cause to believe there's a material defect within the audit itself or a failure to substantially comply with standards and regulations published by the auditor, and we don't believe the auditor presented evidence to support either of those bases for a probable cause. And then finally, if this court were to disagree and find that there is jurisdiction and that there is an authorized investigation, that the claims handling materials are not relevant to it, and the subpoena should be so limited. Thank you very much.
Thank you, Your Honor. Well, that's a lot of ground to cover in 5 minutes. I would say the district court disagrees that all travel documents were turned over. I would point out on page 416 of the appendix, which is page 3 of 12 of the decision, the statement here is, the auditor did not receive all documents it deemed necessary to conduct an audit. Missing records include settlements over $50,000, expenses paid by other individuals or entities, some travel documents, and some contracts. That was based on the testimony of Mr. Cunningham from the auditor's office. I think that statement by counsel that noncompliance, that this is based entirely on an agreement. I don't think this is, the auditor's position is based solely on the agreement. I think the auditor's position is based on the reality of the situation. You know, it's not just that filing with the Secretary of State where we had the admission that it's a 28E entity, it was signed under oath, it was in circulation for 7 years, and although now they're saying it was a mistake, somebody typed that into the form. It wasn't just handwritten. But in addition to that, the agreements that they rely on, this IRMA, this Iowa Risk Management Agreement, which exists on pages 33 is one version, and on page 142 of the appendix, in the preamble, it talks about the formation in 1986 and that it was created by government entities who executed an intergovernmental contract. And then the agreement tracks precisely all the requirements, all the specifications of 28E. So I think it's more than simply just an agreement. It's the sum and substance, the reality of what's been going on here. And I think the other kind of fallacy here is I don't think you have to be one or the other. I don't think it has to be a 670.7 entity or a 28E entity. I actually think the legislature intended them to be read and interpreted jointly, and that's why you don't find any formation information in 670.7, and that the legislature knew that was already on the books.
Pretty much the whole group. I bet a lot of them have 28Es. There's probably 28Es flying all over that group, the pool. I mean, they're counties, and so I imagine they each have been involved in 28Es, but the actual group of the pool doesn't have an overarching 28E, just the contract we've been talking about that's very similar. Is that correct?
That looks like a 28E and smells like a 28E, sure.
With entities that join the risk pool later on, they sign the risk management agreement, right? Is that a 2080 agreement, the risk management agreement?
I think that's the agreement we're talking about. That is a 2080 agreement, yes.
Once the pool is formed, when another member decides to join and pay premium into it, your view is that every subsequent membership is also an intergovernmental 28E contract that needs to be filed with the Secretary of State, et cetera, every single one?
That's a good question. It would seem so under 28E, and I would add that non-compliance with the filing requirements of 28E should not be deemed a defense to the auditor's jurisdiction if, in fact, these agreements should have been filed with the Secretary of State under 28E. That doesn't seem right. It goes to Justice Christensen's concern earlier that somehow you can thwart the...
that they could have been filed, but why should they have been filed? Was there some requirement that they must file those documents? Because they didn't file any of them. So where does that duty come from?
Well, it's specified in 28E that in order to collectively come together for mutual advantage under 28E, that part of the recipe there is filing it with the Secretary of State.
But that assumes that they intended to file under 28E.
Well, I think it also assumes that they understood it was 28E, but I think that the folks that organized this initially, and now they've got professional administrators who are indicating, you know, this isn't a 28E, this is a special 670.7 organization. I don't think, you know, I don't know, I can only speculate, so I guess it's not fair for me to say what
Relevant here? I mean, if you have 800, close to 800 municipalities who all have their own legal counsel, plus the risk management and the risk manager, and nobody thinks this is a 28E entity since 1986, nobody's done any filing under 28E, shouldn't we give some weight to that actual practice? I mean, you keep saying if it is a, you know, walks like a duck, talks like a duck, quacks like a duck, it is a duck. Maybe it's a 670.7 duck. At least that's what everybody thinks it is since 1986. What relevance should we put on that past practice?
concern here by the auditor isn't that this is somehow an organization that should be dismantled. I think the concern is, you know, past practice is that for several years, the board members have gone out of state to conduct some of their business, including public meetings. And I think the question, a fair question by the auditor, the watchdog for the taxpayers of Iowa, is to know whether that is a legitimate use of public funds, that there was a necessity to go out of state for these public meetings. You know, to go to resorts off the coast of Florida and to attend resorts in the Upper Peninsula of Michigan and to do these things on an annual basis. You know, I don't know to what extent the local governments knew or approved of those things. And so that's one of the functions of this constitutional office, the Auditor of State, and the reason why the taxpayers elect that person in that office is to look out for them. And that's all he's trying to do here. And with your help, we can do that.
One follow-up question. How are the claims handling documents relevant to the travel expense investigation?
Mr. Cunningham from the Auditor's Office testified at the evidentiary hearing that they're not. But the claims handling, the settlement practices, and some of the treatment of the pool with respect to competition were a concern of one of the county members of the pool, and they brought that concern to the auditor's attention while they were starting to review this for travel expenses, and so they added it to the mix of items that they wanted to review on behalf of Iowa taxpayers. Okay? Yep, thank you.
Auditor versus unnamed local government risk pools hereby submitted. And we will now have just a brief pause while the attorneys change places for Gov't versus Iowa Utility Board.